Today we'll learn about educators' free speech rights. Last week, we've learned about students' free speech. This week, we'll focus on educators' free speech rights. This is a key area for administrators in K-12 and higher education, balancing legal obligations with the practicalities of running educational institutions. The first case we'll look at is Sweezy v. New Hampshire, 1957. This is a landmark case establishing and protecting the principle of academic freedom in the broader context of First Amendment rights. The case was situated in a period of heightened scrutiny of communist activities in the United States, marked by a broader concern about academic freedom and political expression in the 1950s. Paul Sweezy was an economist, co-editor of a socialist publication called The Monthly Review, and a lecturer on Marxism and socialism. In 1954, Sweezy gave a lecture to a class of 100 students in the humanities course at the University of New Hampshire. This talk was given at the invitation of the faculty teaching that course. Sweezy had addressed the class about such invitations in the past 2 preceding years as well, but he was not a regular faculty member of this university. Sweezy was summoned before the New Hampshire Attorney General, acting under the state's Legislative Investigation Committee's authority to inquire about his political beliefs and lecture content at the University of New Hampshire. Sweezy answered questions about his own activities, but refused to answer questions about his lectures at the university and about other individuals' activities, arguing those inquiries violated his constitutional rights. After refusing to answer those questions, Sweezy was found in contempt of court and sentenced to jail on the grounds that the academic subjects might indicate whether Sweezy was a subversive person. What he taught the class at a state university was found relevant to the character of the teacher. Sweezy appealed the case, and it eventually reached the Supreme Court. In a 6-2 decision, the Supreme Court reversed the lower court's decision, holding that the inquiry into Sweezy's academic pursuits and political beliefs was an unconstitutional infringement on his First Amendment rights. The court emphasized the importance of academic freedom, recognizing that intellectual inquiry and the pursuit of knowledge in academic settings must be protected from undue governmental interference. The ruling underscored the fundamental nature of political freedom in a democracy, including the right to engage in political expression and association as essential components protected by the First Amendment. The court noted the potential for legislative investigations to encroach upon constitutional liberties, especially in sensitive areas such as freedom of speech, press, and political association. The decision stressed that political power must refrain from intruding into the realm of academic freedom and intellectual exploration, except for compelling and exigent reasons. The court stated, in the university, knowledge is its own end, not merely a means to an end. A university ceases to be true to its own nature if it becomes the tool of church or state or any sectional interest. A university is categorized by the spirit of free inquiry, its ideal being the ideal of Socrates, to follow the argument where it leads. This implies the right to examine, question, modify, or reject traditional ideas and beliefs. Dogma and hypothesis are incompatible, and the concept of an immutable doctrine is repugnant to the spirit of a university. The concern of its scholars is not merely to add and revise facts in relation to an accepted framework, but to be ever examining and modifying the framework itself. Moreover, it is the business of a university to provide that atmosphere which is most conducive to speculation, experiment, and creation. It's an atmosphere in which there prevail the four essential freedoms of a university to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. Here the court stated the four essential freedoms of a university. First, freedom of inquiry and research. This freedom allows academics to explore, research, and pursue knowledge in different fields without undue external interference or restriction. It is the bedrock of scholarly work, enabling the discovery of new knowledge and the advancement of academic disciplines. Second, freedom of teaching and discussion. This freedom refers to the autonomy in teaching methodologies and the discussion of different topics in the classroom. It includes the liberty for educators to present and explore ideas and theories, even those that may be controversial or challenge prevailing norms, without fear of censorship or reprisal. Third, freedom of expression and publication. This freedom refers to the right of academics to publish their findings and express their ideas freely. This is essential for the dissemination of new knowledge and for engaging with the wider academic community and the public. Fourth, freedom from institutional censorship. This freedom emphasizes the university's role as an independent institution that resists censorship or undue influence from external forces, be they governmental, political, or commercial. It ensures that academic work is guided by scholarly merit and intellectual rigor rather than external agendas or pressures. The Supreme Court highlighted that scholarship cannot flourish in an atmosphere of suspicion and distrust. Fast forward 10 years, the case of Keyishian v. Board of Regents is another landmark Supreme Court decision on academic freedom and First Amendment rights. The case arose during the era of the Cold War, specifically in the era of McCarthyism, a time marked by heightened fears of communist infiltration and the significant scrutiny of alleged subversive activities in the United States. This period was characterized by aggressive investigations and questioning of individuals suspected of communist sympathies, significantly impacting academic and public institutions. The case specifically challenged a set of New York State laws and regulations known as the Feinberg Law. Those laws required teachers in public schools and universities to sign loyalty oaths and prohibited them from advocating for the overthrow of the government. They also allowed for the dismissal of educators deemed to be subversive, including those who were members of any organizations listed as seditious by the state. Harry Keyishian was an assistant professor of English at the University of Buffalo, now part of the State University of New York system. Keyishian, along with several other faculty members and the librarian, were impacted by the anti-communist policies and regulations, which they argued the laws were overly broad and vague and infringed upon their rights to free speech and academic freedom. The Supreme Court struck down those laws and regulations, declaring them unconstitutional under the First Amendment. The court found that the laws were too vague and broad, creating a chilling effect on academic freedom. The ruling emphasized that academic freedom is a special concern of the First Amendment and that the nation's future depends upon leaders trained through wide exposure to the robust exchange of ideas. The court noted the theory that public employment, which may be denied altogether, may be subjected to any conditions, regardless of how unreasonable, has been uniformly rejected. This statement underscores the principle that public employment, including in education, does not equate to a waiver of constitutional rights. The Keyishian case serves as a foundational case establishing the importance of academic freedom in public institutions of higher education. It cautions against the creation and enforcement of overly broad and vague policies that could infringe upon the First Amendment rights of educators. The court's decision reinforces the principle that educators should not have to relinquish their constitutional rights as a condition of their employment. After learning about academic freedom, let's focus on the broad principles of academic freedom and political expression to a more specific examination of the rights of public employees, particularly educators, to speak out on matters of public concern. Sweezy and Keyishian's case was centered around the freedom of academic inquiry and political affiliation, important in a democratic society, and academic freedom. Pickering's case, however, was about the freedom of a public employee to comment on matters of public interest without facing retaliation from their employer. Who was Pickering? Marvin Pickering was a high school teacher in Township High School District 205, Will County, Illinois. In February 1961, the school board asked the voters of the school district to approve a bond issue aiming to raise over $4 million for building 2 new schools. The community buzzed with opinions, but when the votes were tallied, the proposal did not pass. Undeterred, the school board came back in December with a revised proposal, this time asking for over $5 million. But this round, the community gave the green light. Fast forward to May 1964. The school board proposed an increase in the tax rate for educational purposes. The voters did not approve of the proposal. Not want to give up, the school board tried again in September 1964 with a similar tax rate increase proposal. The result? Another defeat. Amidst this financial roller coaster, articles flooded the local newspaper, passionately advocating for the tax increase. They warned of a potential decline in education quality if the proposal fails. 2 days before the election, a letter from the superintendent echoed this sentiment, and it was circulated widely among the voters. This is where Pickering came in. He responded to the prior publications in the local newspaper and the failed tax increase. In the letter, Pickering criticized the school board's financial decisions, particularly their handling of the 1961 bond issue and the allocation of funds between education and athletic programs. He also questioned the school board's and the superintendent's methods of informing or preventing the informing of the district's taxpayers of the real reason why additional tax revenues would be sought for the schools. The school board deemed Pickering's letter detrimental to the efficient operation and administration of the schools and dismissed him from his position. They argued that the letter unjustifiably impugned the motives, honesty, integrity, truthfulness, responsibility, and competence of both the school board and the district administration. The school board also charged that the false statements damaged the professional reputation of its members, and the school administrators would be disruptive of faculty discipline and would tend to ferment controversy, conflict, and dissension among teachers, administrators, and the Board of Education and the residents of the district. Pickering challenged his dismissal, arguing that his letter was protected by the First and 14th Amendments. The Illinois courts initially upheld his dismissal, but the case eventually reached the U.S. Supreme Court. The Supreme Court overturned the lower court's ruling. The court established what is now known as the Pickering balancing test. This test is used to determine when a public employee's speech on matters of public concern is protected by the First Amendment against employer discipline. It weighs the employee's interest in commenting about matters of public concern against the government's interest in promoting workplace efficiency and effectiveness. The court acknowledged that a public debate is vital for informed decision-making in a democracy. Teachers, as members of the community, should be able to speak out freely on such questions without fear of retaliatory dismissal. The court also protected Pickering's right to make statements in his letter even if they were false, provided they were not made knowingly or recklessly. It underscored the robust protection afforded to speech on matters of public interest. This case provides a clear guideline on how to approach the free speech rights of public employees, a matter of great relevance to educational administrators and the public institutions at large. The Pickering case distinguished between speech made by public employees in their capacity as private citizens and speech made in the course of performing their official duties. When a public employee speaks as a private citizen on matters of public concern, that speech is entitled to protection under the First Amendment. For example, an educator writes an op-ed or a letter to a newspaper or posts comments on personal social media platforms about government policies influencing schools. A teacher participating in a public rally or demonstration about a social issue or educational reform. However, when the speech is a part of the employee's official duties, it may not be protected under the First Amendment. For example, an internal email is sent by a school administrator to staff members discussing school policies or administrative decisions. A teacher makes statements during class that is strictly for the curriculum or school directives. A school principal sends out official communications to parents and the community about school policies and regulations. A public school administrator makes statements during a press conference that contradict official school district policies or directives. They are all speeches as part of public employees performing their official duties. While public employees do not relinquish their First Amendment rights by virtue of their employment, their speech may not be protected in professional settings. Now let's look at another case. Pickering decision established the foundational balancing test for determining the protection of public employee speech, particularly in the context of education. Garcetti presented an important clarification. In Garcetti case, the Supreme Court brought a new dimension to understanding the limits of free speech for public employees, highlighting that expressions made as part of official job responsibilities may not enjoy the same First Amendment protections. Thus, it's important for public institutions, especially educational settings, where the line between personal opinion and professional duty is often deeply entwined and subject to careful scrutiny. Here is the background of the case. Richard Ceballos, who worked at the Los Angeles County District Attorney's Office, had certain supervisory responsibilities over other lawyers. He encountered a case where he found significant inaccuracies in an affidavit used to obtain an important search warrant. He raised concerns internally, expecting his insights may lead to a re-evaluation of the case. Ceballos told the prosecutors who were working on the case they refused to dismiss the case, even though they agreed that the affidavit was dubious. Ceballos took his information to defense counsel, who subpoenaed him to testify. Instead of leading to a positive change, Ceballos faced retaliation for cooperating with the defense. He was reassigned, transferred, and denied a promotion. Ceballos felt Those actions were a direct response to his outspokenness in the memo. Ceballos sued, claiming his First Amendment rights were violated. His case raised a fundamental question. Does the First Amendment protect public employees from discipline based on speech made pursuant to their official duties? The Supreme Court held that public employees are not considered to be speaking as citizens for First Amendment purposes if they are making statements pursuant to their official duties. The First Amendment does not protect them from discipline by their employers. In this case, the employee probably received discipline because of his cooperation with the defense, which undermined his ability to carry out his official duties. The Garcetti decision draws a clear line between an employee's personal speech, which is protected under the First Amendment, and the speech made in the course of performing their official job duties, which may not be protected. This distinction is critical in managing and understanding the limits of free speech within a public institution like a school or university. Administrators need to evaluate whether the speech of an employee, such as a teacher or staff member, is part of their job responsibilities or if it is an expression of personal views. For example, a teacher's critique of a school policy published or discussion about political views in a personal blog may be considered protected speech. However, if the same critique and discussion is made in an internal report, meetings, or classroom, it may not be viewed as part of their official duties. When staff members voice concerns or criticisms related to their job, administrators need to discern whether those are official job duties or personal expressions. This differentiation influences how administrators respond to such communications, balancing the need to address legitimate concerns while maintaining professional standards and decorum. If the speech is job-related, address it within the framework of organizational policies. This may include follow-up discussions, internal reviews, or policy adjustments. A teacher expresses concern about the lack of resources in the science department during a faculty meeting. This should be addressed as a professional concern, potentially leading to discussions on budget allocations or resource management. By contrast, an educator participates in a public rally in their private time, advocating for educational reform and posting about it on personal social media. This is likely a personal expression and should be treated differently. An educator's right to free speech is respected, provided it does not disrupt the educational environment. Let's apply what we've learned to a recent Supreme Court case on educators' free speech, Kennedy v. Bremerton School District 2022. This is a case about an educator who blended personal conviction with public duty. In this case, Joseph Kennedy was a high school football coach at Bremerton High School in Washington State. After every game, Kennedy had a personal practice of kneeling at the 50-yard line and praying. Initially doing so alone, he was soon joined by players and other students. The school district became concerned about this practice. They worried it could be seen as a violation of the Establishment Clause, which prohibits public school officials from endorsing a religion. The school district asked Kennedy to refrain from praying on the field where the students could see and potentially feel compelled to join. Kennedy felt that his personal religious expression was being unfairly restricted. He refused and instead rallied local and national television, print media, and social media to support him. He was placed on administrative leave, leading to the termination of his contract. He sued the school district, claiming a violation of his First Amendment rights to free speech and free exercise of religion. In a 6-3 decision, the Supreme Court held that the free exercise and free speech clauses of the First Amendment protect an individual engaging in personal religious observance from government reprisal. The Constitution neither mandates nor permits the government to suppress such religious expression. In Kennedy's case, the court found that his post-game prayers during a period when coaches were free to attend briefly to personal matters did not constitute government speech. The court argued against an excessively broad job description that would characterize all speech by teachers and coaches in workplace as government speech. Unduly restrict personal religious expression could lead to unreasonable outcomes like penalizing a Muslim teacher for wearing a headscarf or Christian aide quietly praying over lunch. This decision underscores the importance of carefully navigating the intersection of individual rights and institutional responsibilities. This case serves as a guide in balancing constitutional rights with the diverse needs of a school community. In this video, I introduced 5 landmark Supreme Court decisions that shape our understanding and the balance between free speech rights and the responsibility of public employees, particularly in educational settings. Those cases highlight the need for educational administrators to navigate those legal landscape with discernment, ensuring that policies and practices not only respect individual rights, but also uphold the integrity and objectives of educational setting. Here is my questions for you. How can you, as an educational leader, cultivate an environment that both respects the diverse expressions of your staff and students and maintain the necessary professional standards and neutrality expected in public education? Please leave your comments below. I'll see you next time.